Announcements, please.
Walter Boyaki for the plaintiff, Your Honor.
Thank you.
Good morning, Your Honor.
Norton for Del Sol, Your Honor.
Sorry.
Go ahead, Gary.
Gary Norton for Del Sol Medical Center, Judge.
Good
Thank
morning,
you.
Your Honor. Noel Gaddis for Dr. Famalua.
Good morning, Your Honor. Lisa Rushlon. I represent Dr. Adams Gomez.
Good morning, Allison Long for Dr. Daniel Mwanza.
Okay, I think we have everyone. Okay, what is the status of your case, Mr. Boyaki?
It just started, Judge, and we, I think, got to get going on discovery and some depositions set. As you can tell, we kind of got a mob going here, and as you have noted in the past, these medical malpractice cases take forever because it's hard to schedule all these people. So with that in mind, I work well with most of the counsel on the other side, so I don't anticipate any trouble at all. But as you have noted, we got to get going.
Defense counsel, anything else?
Your Honor, Lisa Rushlow, I represent Dr. Gomez. We do have some objections pending to the Chapter 74 expert report, but other than that, that's the only thing I would add that's pending before full-blown discovery could move forward.
And are you wanting to get that set?
We could certainly try to get that set. That would be great.
When was that
Yeah.
filed?
I filed those on September 5th, Your Honor, 2025.
Okay. Okay, so let's take that up first. When do you all want to have a hearing on that? And that would be Defendant Gomez's objections to Chapter 74 expert reports.
Your Honor, could that be by a Zoom hearing, or would you prefer us to be in person?
It can be by Zoom.
All right, then I'm very flexible and whatever would work for plaintiff's counsel.
Judge, I hate Zoom, so I would impose on you if I don't have any problem with defense counsel not showing up for a hearing, but I would prefer to be in person if that's possible. I don't want to impose on anybody though. If your preference is just to Zoom it, that's okay. But as you know, I'm just an old goat and I hate Zoom. So I would object to it, but you know, I'm stuck with your ruling.
Well, I typically say we'll do Zoom unless everyone insists on in person, but I think under the rules, you can make a motion to appear remotely. So, I mean, we can do it hybrid. It's just not always great. So
I agree. I agree,
Your Honor. I'm happy to be in person. I would just ask the court if maybe we could set it that second week in November. And the only reason is because I am in California helping my son right now. And so that would be the only preference if possible, but I'll accommodate whatever the court requests.
Judge, I have no objection to the second week in November. That's fine. If you got time.
So you're talking about the week of November 10th?
Yes, that would be perfect for my schedule, Your Honor.
We just have Veterans Day on Tuesday, Judge. That's the only.
Yes, I'm just noticing that.
Yes, so I think we can do November 12th. That's the Wednesday at 3:30.
Okay.
That would be perfect.
Does that work, Mr. Boyaki?
Works for me.
Okay, so then we'll file an order setting hearing on docket number 26, Defendant Gomez's objections for 11/12/2025 at 3:30 p.m. in person.
Oh gosh.
I heard an oh gosh.
That's a Gary.
Oh, no, Judge. I just accidentally set it for 3:30 a.m. when I was putting it on my calendar.
Yeah, let's
That
not
was
do
my-
that.
That was my only oh gosh.
Okay, so
Sorry.
11/12.
I didn't mean to say that out audibly.
Okay, we have that set, and then we can get the jury trial set. How about October 19th of next year?
Sounds good to me, Judge. And you know how these things are. We'll
Yeah,
probably would not be ready, but we got to have some end date game here.
that'll work, Judge, for me.
Mr. Gaddis, I think that, I don't remember, but you may have been here yesterday or the day before, and we said another med mal case about.
Yes, ma'am. Dr. Verazeres, you set for October 19, 2026. I'm okay. I mean, I'll go on one of those cases, so
Okay.
that's fine.
Okay, does that work for everyone else?
Yes, ma'am.
Yes, Your Honor.
Yes, Your Honor.
Okay, great. So we'll set the jury trial for October 19th of 26. Your pretrial is in person, and that's September 10th of 26. We'll file a separate order setting hearing with the dates and times of the jury trial and the pretrial. We'll also email all of you all, well, it'll go to counsel of record, the form discovery control plan. I prefer that you all use the court's scheduling order. You're free to use your own as long as the content of our form order is included in yours.
Okay.
There's certain dates, like I prefer that you all have mediated the case prior to the pretrial hearing. So there are things like that that I would ask you to include if you're using your own form.
Okay.
Anything else?
No, Judge.
No, Your Honor.
We're fine, I think. Yes. This is definitely hurting cats, but we're doing the best we can.
Keep the cats away. I'm
Yeah.
allergic.
I remember.
Okay, then we'll see you all, not October, November 12th for those objections.
Okay.
Thank you, Your Honor.
Okay, have a great weekend.
Thank you.
Be safe.
Thank you,
too.
Judge.
53. Carmen Brooks, individually and as personal representative of the estate of Joseph Brooks and all wrongful death beneficiaries versus Dr. Familua, Dr. Mwanza, Dr. Gomez, El Paso Healthcare System Limited, doing business as Del Sol Medical Center. Announcements, please.
Walter Boyaki and Mr. Rasmussen for the plaintiff.
Noel Gaddis for Dr. Familua, Your Honor.
Good afternoon, Your Honor. Lisa Rushlow, and I represent Dr. Adam Gomez.
Good afternoon, Your Honor. This is Taylor on behalf of Dr. Daniel Mwanza.
And Gary Norton, Your Honor, for Del Sol Medical Center.
All right, thank you very much. And we are here on defendants' objections to plaintiffs' expert reports. Specifically, defendant Adam Gomez's objections to the reports of Patrick Wallace and Harold Gottlieb.
Judge, I don't think we have anybody else, just the one. Am I correct?
That's all that I have set today.
Okay. Okay.
Okay, Ms. Washlaw?
Thank you, Your Honor. Good afternoon. I represent Dr. Gomez, who is an internal medicine physician and hospitalist. This is a healthcare liability claim. Just briefly, Mr. Brooks underwent a splenectomy that was performed by Dr. Familua at Del Sol Medical Center on June 6th of 2023 because his spleen had ruptured. And then he developed an ileus, which is like an obstruction of the small intestine. And my client, Dr. Gomez, became involved in the care of the patient on June 22nd of 2023. He noted that the ileus of the X-ray showed the ileus and that the abdomen was tense, and he ordered Miralax. And that's, I think, what the basis of the case is about. Miralax is a laxative used to help when a patient may have constipation. The following day after the Miralax was ordered, there was a stool specimen that was obtained from Mr. Brooks, and it showed C. difficile colitis. And then a few days later, after that, on June 26th, Mr. Brooks had to have surgery for a perforated right colon. Dr. Gomez's last day of care was on June 26th of 2023, and Mr. Brooks subsequently required a colectomy or removal of the intestines on July 14th of 2023, which was 18 days after Dr. Gomez provided care, and then he died unfortunately on August 31st of 2023, which is a little more than 2 months after Dr. Gomez provided care. So suit was filed in this case, Your Honor, originally against my co-defendants, Dr. Familua, Dr. Mwanza, and Del Sol on June 2nd of 2025. My client was added to the case on July 17th, 2025. These when I filed my answer, I was provided that same day with the Chapter 74 expert reports of Dr. Wallace, Dr. Patrick Wallace, who is a surgeon, and then Dr. Harold Gottlieb, who is an internal medicine physician. Those reports are dated, Dr. Wallace's report is dated July 8th of 2025, and Dr. Gottlieb's report is July 16th. Both of these reports were dated before Dr. Gomez was actually added to the lawsuit. In any event, Your Honor, Chapter 74.351, subsection R6 requires the plaintiff to provide an expert report within 120 days after a defendant files its answer. And so the plaintiffs did timely serve these expert reports. Now, the expert report has to include what the applicable standard of care is as to Dr. Gomez, how that was breached, and then the causal relationship between that alleged failure or breach of the standard of care and the injury or harm and damages claimed. If the report omits any of those statutory elements, it is not considered a good faith effort, and inquiry is limited to the four corners of the report. Now, the case law does clearly say, Your Honor, that you can consider more than one expert report. And so I've looked at both Dr. Wallace's report and Dr. Gottlieb's report, and I believe that they are insufficient to establish causation as to Dr. Gomez. Dr. Wallace's report, dated July 8th, he doesn't mention Dr. Gomez anywhere in his report. Okay, Dr. Gomez's name is never mentioned. And so I don't believe that the report of Dr. Wallace in any way is related to Dr. Gomez, but I did assert that just in case the court was to consider the two reports collectively, if you look at Dr. Wallace's opinions regarding causation, his criticism revolves around the use of a different drug, neostigmine, in a patient with C. difficile colitis. So Dr. Wallace, number one, does not give any opinions regarding the standard of care for Dr. Gomez, and his opinions regarding causation relate to a drug that Dr. Gomez did not prescribe. So then if we then go, Your Honor, to the expert report of Dr. Gottlieb, he is an internal medicine physician, and I did not object to his qualifications to give opinions because I think he is qualified, and I don't have any concerns with that. But if you look at Dr. Gottlieb's opinions, he sets forth in his facts on page 2 of his report that Dr. Gomez on June 22nd, 2023 noted that Mr. Brooks's abdomen was tense and distended, and his plan was Miralax and Senna, S-E-N-N-A. Senna is also a type of a laxative. And then Dr. Gottlieb clearly states the next day, June 23rd, Mr. Brooks was noted to have the Clostridioides difficile, which is associated with diarrhea. And he notes the order for neostigmine. Okay, so those two dates I think are pretty relevant. But then if you go to page 4 of Dr. Gottlieb's report, this is the place where Dr. Gottlieb identifies a standard of care criticism of Dr. Gomez. And he says that Dr. Gomez breached the standard of care by ordering Miralax when his examination on June 22nd showed that the abdomen was tense and distended. Miralax should be avoided in patients with active Clostridioides difficile infection. Well, we didn't have an active infection on the 22nd, but in any event, that breach of this, the alleged breach is about ordering Miralax. And all he says is that that using it if diarrhea is present may worsen symptoms. He doesn't say that proximately caused the need for additional surgery, didn't say approximately caused his death. He doesn't really tie together the use of Miralax in all of the subsequent care that Mr. Brooks received. And then if you go to his section under causation and injury, in his report, Dr. Gottlieb, still on page 4, Your Honor, he talks about the breaches of the standard of care by Dr. Famalua and Dr. Mwanza. And then on page 5, he talks about this breach, the causal connection in regarding his opinion regarding the care by the nurses and respiratory therapists. But in that section, nowhere does Dr. Gottlieb say anything about Dr. Gomez. And so and then even in his conclusion, he talks about the standard of care calls for a surgeon to perform surgery in a competent manner. And he talks about the nurses and respiratory therapist that may have allegedly contributed to the development of a colonic perforation and pneumonia. But nowhere does he say anything about Miralax proximately causing injury. And so I felt a need to object to these reports, Your Honor, because although there's an allegation of a breach of the standard of care, that's nowhere tied together in these Chapter 74 reports as to how that proximately caused any damage or injury to Mr. Brooks. Now, the plaintiff in his response has noted that if the court does find that these reports are insufficient, that they are entitled to a 30-day extension to potentially cure that. I don't disagree with that, Your Honor. I think that is an accurate statement of the law. And I would have no objections to that. But I just think collectively, when we look at these reports, the alleged act or omissions attributable to Dr. Gomez, they're not tied together with a proximate cause opinion by either of these experts. As I said, Dr. Wallace strictly addresses proximate cause as it pertains to a different drug, neostigmine, nothing about Miralax, and Dr. Gottlieb does not tie it together in his proximate cause opinions. And therefore, I do believe that our objections should be sustained as there's no causal connection in these reports. That's all I have. Thank you, Your Honor.
Thank you. Mr. Boyaki?
Judge, I wanted to criticize you today for making us do this on Zoom. We much prefer to have these things in person, but just to let you know, my cat had no objection to me staying here. Just so you all know, the judge always complains to me that she's allergic to cats, and so my cat's here today. So anyway, the other thing you can blame me for, this whole Chapter 74, I don't know if the younger of you know, I am responsible for Chapter 74. You're looking at the guy who caused Chapter 74. When we used to have 4590I, the statute, I'm the dope that got it declared unconstitutional by the Texas Supreme Court. Now, just to show you, I consider myself too smart by half, and there's the basic conclusion. The old 4590I used to have a cap of $500,000, and now it's $250,000. So like I told you, I'm too smart by half. Now, the other reason I'm mentioning this to you is that I was involved in the changing of the statute to Chapter 74, and what has happened to it, and you can see it at the Court of Appeals opinion. Our Eighth Court of Appeals says enough is enough on these objections to these reports. Judge Hecht, when he was Chief Justice, complained bitterly about them because virtually every single case somebody's complaining about the expert reports. I have to give local counsel credit. That doesn't happen locally, but for you folks out of town, we see them in virtually every single out of town case. I don't know if it's at the seminars, they're telling you got nothing to lose by filing them, but they're very difficult to deal with. Now, why I'm saying that to you is because we had a real tough time figuring out how to separate the good cases from the bad cases. And we were not going to the New Mexico standard or a standard whereby you had to have a report or a committee or some type of committee to rule on these things, whether you could go forward or not. So they came up with a report under Chapter 74. It was never entitled to be the stopgap that it has become, and that has been buried the courts. If you can see in my motion, it's 15 pages here. I think there's probably 30 cases that are mentioned. You can read these cases all day long. Oh, and I should tell, I forgot to give Mr. Norton credit. When he was at Scott Hulls was in the case with me on the Court of Appeals to declare the statute unconstitutional. His old partner, Charlie Jones, may he rest in peace, he was with us the whole time. I think, Gary, I don't know if you were even there at the time when we did this. I may be predating you here. Anyway, so you got to be an old goat to understand this, how old this fight has gone on. But the important thing, it was supposed to be a low bar, and it was supposed to be not a trial or a summary judgment type evidentiary situation. You were just supposed to have something halfway decent to tell the doctor that he had a potential claim against him. You'll see that in all the cases. And Judge, I even sent you the newest one from the 14th Court of Appeals, this Oka Rende case, which does a real good job at showing you how all this statute comes together. So it was never intended to be what it has become, which is the dam to prevent all of these cases. Now, in this particular case, counsel is correct. You can take both experts together. That's exactly what the statute said, and no report is required to be evidentiary as to each and every element of the case. You're just supposed to tell these people, low bar, this is what you have. I equate it to a traffic accident. You got to get out of the car and see what kind of damage you got to the car, or what kind of damage you got to the persons. That's what was envisioned by this before our out-of-town counsel went crazy on these things and makes me do this in every single case. So in this particular case, if you look at what Dr. Gottlieb and what Dr. Wallace are saying, and they are telling you, you gave this guy, in addition to the rotten surgery that he starts out with on his spleen injury, he winds up with a perforated colon, no colon, and dies from sepsis and pneumonia. And this is what you get with the two drugs that are in question here, this Miramax and nestagamine. And Dr. Gottlieb does indeed address both of them in his conclusions when he said, because Mr. Brooks suffered numerous operations and complications during his hospital stay, he never recovered and ultimately dies. And that's what you have here. Dr. Gomez has mentioned by name that you shouldn't have given this medication. It causes diarrhea. Here they blow out his colon, and what do you think he dies from? Sepsis from the diarrhea getting into his body. So we have enough here, Judge, for you to just look at it, and you just the easiest way to do this, because I think Mr. Gaddis, Mr. Norton, and I think we're probably into our third year of surgical residency here on these cases, because we have to get into them so much. I think if you stand back here and say, what happened to this guy? And you sit there and say, the doctors are telling you these two medications given to this guy with a spleen injury blow out his colon and they kill him. And this is what happened. And it's not hard to see who's in charge of this patient. So we sue all the patients, we sue all the doctors, and we have a relatively, I think, clear case as to what's going on here. And if you look at every single case that I've cited to you, Judge, and like I said, I'm sorry to give you all of that information because it's so laborious, and these cases are they're so different in many ways. And what else could we have added here? I don't know. I mean, we just told them this is what happened to the guy. And I'm not saying that they can't go to depositions and try and disprove it, or to say to Dr. Gottlieb, for example, well, the diarrhea didn't kill him here, did it? And it was the other drug that blew out his colon, and then leave it to the doctor to fill in the blanks. And that's what was envisioned when we did this crummy statute. And like I told you, partially my fault, because we didn't think it would ever go this far. We were just looking for something kind of just make it that so that you couldn't just sue these people for nothing. And I don't think it needs a 30-day repair, Judge, because what would Dr. Gottlieb further say? Is that this drug and the stagnant mind are the ones that killed him. Thank you very much. It's right there. It's right there. I don't think we need to finish my surgical residency to come to that conclusion. And that's
Mr. Boyagi,
yeah.
I'm sorry, go ahead.
I think that's all I have.
Okay, let me ask you this. I didn't see any references as to what physician ordered the neostigmine.
That was ordered by the surgeons. Gomez ordered the Mirax. And as a matter of fact, Judge, you're right on point, because counsel mentioned that in the original report, Dr. Gomez was missing. What had happened was Dr. Gottlieb called me and said, "Hey, you forgot somebody here, pal. That this is contributed to the death of this individual." So the other drug, not the Mirax, it's the one, and that's a one that weakens the colon, and that's the one that puts the hole in the colon. The problem that you have is now you got diarrhea all over the place, and that's the last thing you need is a hole in your colon. So that's how that all comes together.
Okay, so is it your position that Dr. Wallace's report addresses the actions or inactions of Dr. Gomez?
I don't think, to tell you the truth, Judge, I don't think so, because we hired him primarily because it was a surgery case. And you start out with a splenectomy, and I was trying to avoid the objections to Dr. Gottlieb not being a surgeon. So we put the two of them together. But I think counsel is correct. I don't think Dr. Wallace mentions that, but once again, that statute was specifically and says so in the statute, you take the two reports or the 3 or 4 reports together. You don't separate them out. So I think what
Sure.
Gottlieb then rolls them in together, and it's both drugs, not just the one.
Okay. Okay, so your position is if Dr. Wallace doesn't really comment on Dr. Gomez's actions or inactions, you're still reading the two reports together to understand
How this guy died. Yeah.
all of the medications that were ordered in addition to the surgeries.
Yes, ma'am.
But is it enough, if you're looking at only Dr. Gottlieb's report, is it enough that he says that the drug that was ordered, it says may worsen symptoms?
Right. But then he goes on to say, Judge, that if you look at it, when he criticizes the nurses, and that's when he says it again, the sacral ulcers and the contributing to the colonic perforation, and then he says that the nurses were responsible for giving these drugs, in addition to the fact that they were ordered. And I can find that line for you if you're looking for it. Let me see. I thought I had.
Because the paragraph that I'm looking at on page 21 of your response, and it's on page 4 of the report, looks like 1, 2, 3, 5, the 5th paragraph down that starts with Dr. Adam Gomez.
Right. Go to the next page, Judge, and you'll see the last page, which has Dr. Gottlieb's signature. The nurses failed to have adequate skin care for Mr. because he developed sacral pressure ulcer, and they presented, and if you look, the paragraph above that, which we were mentioning, the nurses contributed to Mr. Brooks's colonic perforation because they did not question administering Miralax and neostigmine to the patient in Mr. Brooks's condition. He puts them together right there without it being objected to or without it being slighted or anything else. It's straight up. And if that's not acceptable, I think that's what we're telling these people. This is what happened. And I think council is well prepared to say this is, if you're saying this is what's missing, it's because you already know these reports don't have to be perfect. They don't even have to be good. They just have to be basically approximate cause is basically all it is. And I think between Dr. Gomez mentioned and the fact that that Dr. Gottlieb mentions the condition that this did not questioning administration that caused the perforation, I think it's there. But if the court wants me to get an amendment to it, it's not very hard, and I think it's kind of a waste of time. But if the court needs it, I'll be more than happy to do it.
Well, I think the question is just, I understand the low threshold. I understand the purpose of the expert report, but I wondered what authority there is for the type of language, because it doesn't appear that Dr. Gomez did very much in the grand scheme of things. And what I mean by that is just that he's the one only administering one drug, it seemed like, the Miralax.
Yes, ma'am.
And so, and even at that, it looked to me that there was some speculative language on what it might or might not do. And so that's why I posed the question to you.
Okay. Judge, I think it's fairly clear, and I think the combination of the two drugs is what kills this guy. And I think it doesn't have to be a big hill to climb here. If that's an inference that you can get, you're entitled to that inference. You don't have to put to rest all the potential defenses. However, as I told you, if the court has trouble with it, you can see it. It's not very hard to correct it, and if it's not very hard to correct it, then it shouldn't be an objection to it. If it looks like it's very obvious to everybody, it looks like it's obvious to me. But far be it for me to question that these guys have trouble with these reports, because as I told you, we get them in every single case, every single one, and not necessarily from our local people.
Okay, and did I miss it? Did Dr. Gottlieb also opine on the administration of the neostigmine, other than the reference on page 5?
I think he does, but that's one of the reasons why I had Dr. Wallace in the case, because it is a surgical drug. That's absolutely a surgical drug, which is contraindicated in a situation like this when you have a frozen. It's called a megacolon, Judge. It gets huge. Not something anybody would want. And he does mention that, as we talked about before, the both drugs ultimately at the end of his in causation. So that was about as good as I could do, knowing what little I have. Don't forget, we start out with medical records that are usually about 3 feet high, and I'd have to criticize Mr. Norton's hospital because they repeat the same thing over and over and over again. I think they get paid by the word over there. But I don't like to criticize Mr. Norton because he is my pal.
Okay, Ms. Rochlow.
Credit for that, but that's okay.
Ms. Rochlow, if I understand the facts based on the motions, the objection, the response, and then the experts' reports, the Miralax was administered by Dr. Gomez, or at least ordered by Dr. Gomez, on June 22nd.
That's correct, Your Honor.
Was it also administered by the nurses on June 22nd?
I am not 100% certain. I would have to double check that, if it was actually administered.
Mr. Boyaki, do you happen to know? I'm asking this specific question because I understood that the neostigmine was administered, or at least ordered, on June 23rd.
Judge, once again, this is the argument we get in on Chapter 74 all the time. I'm not sure, and I don't want to tell you yes because I don't know, and I'd have to go back and check it. And I think that's why the Supreme Court's telling you got a low bar here, because it's very hard to nitpick these things to death. You can do this in every single case. And all they're trying to tell you is, do you have a legitimate claim? That's all the issue is.
And I get that, but there has to be a legitimate claim as to each defendant too, right?
And that's why Dr. Gomez is mentioned in Dr. Gottlieb's report. We try to do that every single time, because otherwise we get the objection every single time.
Okay. Any rebuttal, Ms. Roshlow?
Your Honor, just briefly, the statute is very, very clear. I'm not trying to embellish or make them do summary judgment proof or anything of that nature. It's very clear that the expert reports has to set out the standard of care and how that proximately caused the causal relationship. And I know there's been multiple references to me not being local counsel. I will tell you, Your Honor, I've been representing healthcare providers for over 30 years, and I am very judicious when I file objections to Chapter 74 reports. And my client, we were questioning, where's the causal connection? Where's the causal link set forth in these reports that Miralax, as opposed to failed surgeries or neostigmine being administered, where is this set forth that there's a causal link to his subsequent requirements for whatever it was, sepsis, surgeries, and death? He mentions that there was the blowout of the colon. That is nowhere referenced in this report. We are limited to the four corners of the reports. So any conversation he may have had with Dr. Gottlieb is obviously not to be considered, but I just think that we're missing causation. And I don't think you can infer by a statement about the nurses administering Miralax at some point in time that is equating to an order for Miralax by Dr. Gomez before a diagnosis of Clostridioides difficile infection was even obtained.
Judge, if I may, I didn't know, Ms. Rothstein, are you done?
Yes, I am.
Okay. If you look at Dr. Wallace's report, see, your question is critical, because see, the Miralax is a stool softener, and it doesn't have to work immediately like the surgical is. And so if you look at Dr. Wallace's report, the last paragraph, he's talking about, and by the way, they did blow out this guy's colon, in case you wanted to know. He talks about in the paragraph above that, massive colon distension, both can develop colon perforation, and both can cause colon perforation. And if you look in the next paragraph, it can worsen the condition and precipitate perforation. Treatment guidelines are telling you to avoid these agents when you have this type of colitis. And these agents are only started once an infectious disease colon extension has been ruled out. So what happens is Miralax makes it worse. And so when the colon then unfortunately perforates on you, here it comes. You have diarrhea then pumped into the system. So it's the two drugs together. And I think Dr. Wallace is trying to tell us that once this perforation happens, the infectious cause of the colon distension has to be ruled out. And so that's why they come together. And it's fairly obvious to me what happened to this guy. But like I said, if you want me to fix it, I can.
Ms. Roshlow, were you making the point that going back to Dr. Gottlieb's report, in the paragraph where he gives an opinion about Dr. Gomez's ordering the Miralax, did you say that the Miralax was ordered on June 22nd at a time when they didn't have the diagnoses of active Clostridioides difficile infection?
That is correct, Your Honor. That diagnosis came the following day, and I think it was later in the day, like around 5:00 p.m. I think there's a note that the lab called the nurse. So yes, it was the day after. And just, Your Honor, Just briefly, Dr. Wallace's report in no way references Miralax. In fact, the first paragraph of his report states, I believe the majority of his care was appropriate. My criticism of the case revolves around the use of neostigmine while he was being treated for C. difficile colitis. He mentions Miralax nowhere in his report.
Judge, also, if you look at the paragraph on Dr. Gomez that Dr. Gottlieb writes, he's showing you that what Mr. Brooks had at the time was an abdomen was tense and distended. So this was not a new condition that they were treating him for. This was in progress. And that's why this drug is ineffective, because it unfortunately then with the other drug it ultimately causes the death. And like I said, that's the difficulty you have in a Chapter 74 report. Once you get in line by line, that's not what was envisioned on these things. This is supposed to be, do you know that there's a claim here? Does the claim have some merit to it? And that's all that's required. And if you go line by line on these, we're having to try the case.
Okay, I'm going to grant defendant's objections and require the plaintiff to amend within 30 days from today's date, and specifically to address the issues with Dr. Gomez and the causation issue. I see that there's an opinion he breached the standard of care, that he should not have ordered Miralax when he did. But what I think is missing is the next part of that, how it contributed, the causation. And I'm not saying that it doesn't meet the summary judgment stage, that it's just not enough to get to the contribution to the ultimate death of this individual.
Judge, I have no problem with that. So just so I'm clear, she's not objecting to qualifications. She's not objecting to standard of care. I just need to address causation.
That is correct, Your Honor.
Yeah, that's what I understood. I didn't read anything about qualifications. I understood it was only the kind of causation issue.
Okay.
Ms. Rushlow, if you have a proposed order to that effect.
I do, Your Honor. I'm actually in your courtroom right now because I was already here. I could give it to your staff. I have a proposed order, or how would you prefer I handle that?
You probably haven't circulated that with counsel, have you?
That I have not. I can certainly do that, and then we could submit it.
Okay. Yes, I would prefer that, just so that everyone has a chance to review it. If there's any huge issues, I'm sure Mr. Boyaki will let everyone know.
Okay.
Otherwise, and if you give him a reasonable time to respond, maybe by tomorrow or the next day, and he doesn't respond, which I can't imagine that will be the situation.
Nope.
Then just let us know, and then we can enter it accordingly.
Okay. All right. Thank you, Your Honor. I will try to get that to him later today or for sure tomorrow.
Okay.
All right.
Wonderful. Thank you all. And my apologies. I know we had it set up for a hybrid hearing. My apologies for having to change it. I did not account for a flat tire, and I didn't want to cancel and reschedule the hearing. So I figured this was the easiest so that we could maintain the hearing.
It's okay.
No worries, Your Honor. Your staff has been wonderful too. So
wonderful. I'm glad
Judge,
to hear that.
I was just going to add that it did afford me the opportunity to witness a drug deal here in the police parking lot. So, there we go. At least that's what it appeared to be.
Go arrest them.
I have many questions about that, but we're still on the record.
Yeah, I hear you. But it was, they've already left, but I'm pretty sure of what I saw. So there we go.
All right. Well, everyone be safe and have a good evening.
Yeah, this is 2023 DCD 1205, Gina Ruiz versus Sam's West Inc., doing business as El Paso Sam's Club. Announcements, please.
Good morning, Your Honor. Daniela Rabinotti for the plaintiff.
Good morning.
Good morning, Your Honor. Diana Hernandez on behalf of defendant Sam's West.
Good morning. Okay, we're set this morning on defendant's supplemental no evidence and traditional motion for summary judgment. Ms. Hernandez, you may proceed.
Thank you, Your Honor. Just a quick background on this case. This case is a premises liability claim. It arises from a slip and fall that occurred on June 20th, 2021. While shopping in the frozen meat section, plaintiff slipped on a clear water-like substance that came from a package of leaking meat. Defendant's position today, and as we believe the summary judgment evidence will show, is that the spill was created by another customer, Norma Mendoza, about 75 seconds before the fall. As you know, to succeed on a premises liability claim, the defendant must establish that the property owner had actual or constructive knowledge. This is a dispositive issue before the court today, and that's whether or not the plaintiff can establish actual or constructive knowledge. Now, in my analysis, I want to go ahead and start with actual knowledge. Plaintiff's theory today, and the main narrative that plaintiff is giving forth today, is that Sam's Club had actual knowledge of the spill because it was a Sam's Club employee, specifically a meat cart stalker, who created the spill. And plaintiff is correct in stating that the time notice rule doesn't apply when there's actual knowledge. However, we believe today the evidence will show that we conclusively negate the theory that the Sam's Club employee created the spill. In plaintiff's response, again, and all of the evidence, plaintiff relies solely on her own deposition testimony in an attempt to create this fact issue. Plaintiff alleges that the manager of the Sam's Club, Nestor Garcia specifically, admitted to her that the spill came from the Sam's Meat restocking cart. However, we do not believe this is competent summary judgment evidence. There is no supporting testimony from any other witnesses or additional circumstantial evidence that is not speculation to support this self-serving alleged statement.
Ms. Hernandez, is that an admission by a party opponent?
It is, Judge.
Well, the issue is that we don't actually have any evidence that he made this statement. So if he had actually made this admission, it would be. But there's no evidence in the record besides this one instance where he said that. And it comes from plaintiff herself. Later on in the deposition, there's no mention of it in the incidental report.
Okay, go ahead.
Again, there's no mention of this in the customer incident report, which was taken at the same time that the incident happened. And specifically in Nestor Garcia's own sworn deposition, he states that he learned from another associate that the customer had actually reported to her that she created the spill. And that was Norma Mendoza again. In addition to this, the video footage corroborates this. And we have it available here today for you if you would like to see. And in addition, in the customer incident report, they actually took Norma Mendoza's information, including her phone number. They were just unable to get a statement because she left before she was able to fill that out. And you can actually see that in the video. Regardless, even if plaintiff's deposition testimony is enough to defeat summary judgment under a no evidence standard, it's not enough to overcome the fact that defendants have conclusively negated the fact that a Sam's Club employee created this spill. Again, our evidence establishes that Norma Mendoza created the spill. There's circumstantial evidence, i.e. specifically that she was reported in the customer incident report. There's Nestor Garcia's own sworn deposition testimony in which he states that she created the spill. There's also a picture of Norma Mendoza's car, and you can see, you can see Nestor Garcia actually taking this picture in the video that shows the leak coming from under the shopping cart. And in addition to that, we also were able to obtain Norma Mendoza's own sworn affidavit stating that she created the spill. Most importantly, we also have the surveillance footage, which clearly shows the source of the spill was Norma Mendoza's cart. Plaintiff states in their response that the events show the employees cleaning by the meat cart. However, if you actually view the video, you can see that they're cleaning under Norma Mendoza's cart, and you can even see them bagging Norma Mendoza's chicken and placing it back in the cart to prevent further spillage. Again, this evidence can't be discredited, although it is contrary to the non-movement, because a reasonable juror could not discredit this evidence. Basically, since there's no actual knowledge, then we would turn again on constructive knowledge. So because defendant has not conclusively because defendant has conclusively established that Norma Mendoza created the spill, the case turns on whether or not their Sam's Club had constructive knowledge of this incident. Again, the video shows that Mendoza parks the cart with the leaking chicken at about 1:05 p.m. and 29 seconds. Plaintiff falls at 1:06 and 42 seconds. So this is about 75 seconds that pass between the alleged spill and plaintiff's fall. This is not enough time for Sam's Club to have discovered the spill through reasonable inspection. And there's no evidence provided, again, by the plaintiff that that spill was there for a long time or any sort of duration. Again, there's previous case law to suggest, there's previous case law stating that 97 seconds specifically is not enough to establish constructive notice. And this isn't a case out of the 8th Court of Appeals as well.
And what case are you referring to?
This is going to be Slape v. Walmart Stores, Texas. Your Honor, ultimately, again, Reese will be controlling this case today. We cannot establish actual knowledge, so it's going to turn on constructive knowledge. Plaintiff hasn't actually provided any evidence that the spill was there for a long duration. And again, we've conclusively established the fact that the spill was created not by the Sam's employee, but again, by the Norma Mendoza herself. For that, we respectfully request that you grant summary judgment on behalf of the defendant today. Thank you.
Thank you. Ms. Labinati?
May it please the court, Your Honor, I'm very surprised that we are here in this motion for summary judgment. With all due respect, clearly the defense counsel, young counsel, does not understand the fact issues in this case. This is a motion for summary judgment. The court must the evidence goes into the favor of the non-movement, and that's the plaintiff. The court has to, under the law, the court must not weigh the evidence. It's not up to the judge to determine who to believe, one witness or the other, one evidence or the other. That is weighing the facts, that's weighing the evidence, and that is actually against the summary judgment standard. The question is, if there is any fact issue, the court must side with the non-movement, and the evidence goes on the side of the non-movement, not to the movement, and it's up for the jury to weigh the evidence. What the young defense counsel has done for the first time, actually, she's literally asking the court to ignore all the other witnesses, all the other evidence, including the deposition, which is dishonest, of their own store manager who say to the contrary, which now I'm going to read it on the record, for the court to somehow weigh that and ignore everything else. And she's just citing some case law and saying, I have an affidavit, hearsay affidavit of a customer that was disclosed 4 years later, not by the other attorney, with audacious arguments that somehow plaintiff's counsel that has never spoken to this witness, we didn't even identify her, we didn't even speak to her, somehow we even threaten her. This is insane. Ignoring, if the court has read all the depositions, which I'm concerned right now, because this is not about law, this is about facts. Their own witnesses are saying, which is Nestor Garcia and Rachel Minus, store managers are saying, we don't know if this was caused by our own employee. The video is not clear. They're the defendant. I'm not sure if Diana is going to be the defendant in this, a witness in this case, Your Honor. I would love to disqualify her, but in her eyes of seeing the video saying, oh, this came from the customer, when their own Walmart employees, Walmart witnesses, in their deposition that is attached, and I will read it on the record, but I'm summarizing right now, they say, we have looked at the video and we're not clear if it actually was our own employee's fault, quote unquote. So we have the defendant saying, oh, you know what, maybe our own client, maybe our own employee caused it. We're not sure. But this attorney comes here in the courtroom and tells this judge, oh no, judge, that's not what the video shows. The video shows the video shows that it came from the customer, when they're her own client and two of them, not even one, say the contrary. And she's asking the court to ignore her own client's testimony. Well, if her own clients are saying that maybe it came from their own employee, what about the 12 ladies and gentlemen of the jury? They are maybe agreeing with the defendant and my own client after listening to the entire evidence. And in fact, Your Honor, we have additional evidence which was not submitted in the response to the summary judgment because I thought this was enough. This is unheard of on an admission by party opponent to even have a hearing, a motion for summary judgment, which I'll be happy to submit to the court. And she knows because I advised her boss, Mr. Mitch Moss, Mitch, we got new evidence, we got new testimony. Let's do some more depositions so we can try to settle this case. So that's also untrue. But it's not part of the record. I'm happy to ask and to submit it, but this is plenty, Your Honor, to deny this motion for summary judgment on a he said, she said, other than an attorney, she's not a witness, asking the court to ignore all the other witnesses and just to believe an affidavit that she put together after they got the case and not by the former attorney that had the case for 4 years, which I have been asking for that person's deposition as well. And we are also asking for her statements that are in violation of Rule 801 and 802 and 803 to be completely stricken off the record because they are absolute hearsay. She's not able to identify any of those individuals. So
okay, let me stop you because I'm not following you. I don't know if you're asking for a motion for continuance to do some additional discovery. You're talking about things that are not in the record. And then now you're referring to her. And I don't know, a minute ago you were talking about a Diana. I assume you're talking about Ms. Hernandez, opposing counsel.
Yes, I am talking about Diana, Your Honor, that she knows that there are, because she said that there was no other witnesses. But what I'm trying to tell the court, I'm trying to give a history of the case because this case was the witness that she's referring about. That's the witness that they disclosed. And so I don't know if the court wants to start with the objection to the affidavit, but I try to give the court a summary of the case. So as far as the summary of the case, I want the court to realize that literally the court is asking to weigh fact issues. And when she said that the customer, because to me, that's like the elephant in the room. She's telling the court, believe the customer affidavit and ignore the depositions of the manager and ignore the deposition of the plaintiff and ignore the deposition of assistant manager. I think that's a big elephant in the room on a motion for summary judgment. But I'll start in the beginning. However, Your Honor, just on that fact alone, that their own witnesses, their own store managers are contradicting this affidavit, which is hearsay, by the way, she's relying on, that is a denial, a motion for summary judgment as a matter of law. Now, let's start with the issue of constructive knowledge. The law that she's talking about, Your Honor, the 96 seconds is not applicable in this case. I mean, I find this like so easy to understand, yet it's become complicated somehow. That is a matter on a situation where the employees are not in the area. And so like when they were first found out about the condition, did they have enough time to clean it? Not in a situation, Your Honor, when their own employees are saying maybe it came from the card of our own employee. There was a negligent activity taking place at this time. The employee in the video, Your Honor, you have seen the pictures which are part of the record, is at all times present in the area where the client fell, where the plaintiff fell. That's not disputed, Judge.
Let me ask you because I've reviewed the video, I think it's Exhibit A. At what timestamp does the video show that the meat cart is in the vicinity where the plaintiff fell?
So if you look at between 1251 and 101, Your Honor, that's where, and also the defendant's deposition, you don't even need to do that job, Judge. It's on the defendant's deposition, Rachel Maynes and Nestor Garcia. They both testified that the employee was working in the area where the plaintiff fell at the time. It's in their deposition testimony, Your Honor, and that we've included and highlighted in our response. I'm not sure if the judge got a printout of the response, but it is in our response. So she's completely ignoring her own client's deposition testimony, Judge. And Rachel Manus testified to that. I played the video to them, and they all agreed that their employee was working in that area. What happened, Judge, is he was picking up the boxes of the meat, right? And he was putting it in the freezer, and then he moved the cart in the same area to the left, and then he went to the right. So the whole time he was right in that area working. So I'm gonna start reading some of the deposition testimony, but let me start from the beginning, Judge. When an employee creates the dangerous condition as a matter of law, that's constructive knowledge. You don't have to notify them. They are right there and they are working on that area.
Isn't it actual knowledge? Because they're creating.
That is either, well, they are creating, but they might not be aware. So like I can do something negligently, technically, I might not be aware I'm doing it. So it's either actual or constructive. So even, I mean, the Fifth Circuit has been clear on this. You can read Grolia Armendariz versus Walmart, Your Honor. That's my case. We took it up to the Fifth Circuit and we reversed summary judgment on Judge Martinez because they said, well, they did not know. The employee says, well, we did not know. And the Fifth Circuit says, absolutely not. Once you created, you are the one who placed that. And in that time, actually, Gloria Armendariz, they had left. And so they said, the court says that's constructive knowledge, but because they weren't there at the time, but they set it up. In this case, Your Honor, it can be, I mean, I would argue both, for sure constructive, maybe even actual. I haven't taken his deposition, but the Rachel Mena says, we're not sure by looking at the video, it could have been our employee because he's right there and he's picking up the boxes. And she even says, quote unquote, I am not sure. I'm looking at the video. It could be my employee or not. It's not very clear on that video if it's my employee or not. But what we know, he's there. And what she said is what we know, even if he didn't, maybe is the one creating it, which it could have been. She agreed that under the Walmart policy, they have a continuous duty to inspect the floor, and he was at all times. And so we asked him, you agree with me they have a continuous duty to inspect the floor? You agree with me that if you look at the floor, you'll see the droplets? And she said, absolutely, yes. So constructive knowledge, yes, by him being there at all times as this activity taking place, but also probably actual knowledge, assuming he saw that when he was putting it, it actually fell. But it could be, Your Honor, to where he's creating the dangerous condition, but he's not in his head paying attention and realizing it, that it's coming, that it's actually leaking as he's taking it from the cart into the freezer. At the entire time of the video, Your Honor, within that period of time that my client fell, he's there working on that same freezer and he's moving the cart. And you can see on the video, Your Honor, and you can look at the video, but you don't have to look at the video because it's in the deposition testimony of their own employees. I went through the video with both of management and they agreed with me, Judge. I mean, there was not even an objection on my questions. I have clear admissions, and they all agreed that the trays weren't in there and the trays was missing. And the fact that they are having these carts, they're having frozen potentially that could leak. I mean, that unfortunately, as the court knows, I mean, even when we buy groceries, we put in the refrigerator, you got to be careful if the leakage come out of the package, it could leak on the floor. And so unfortunately, I don't know why they don't have a trace in there, but they also said, yeah, you're right. There is no trace. So it could actually leak from the cart, or it could leak as he's placing it on the freezer. But even then, Your Honor, there is no question, he's the one putting that meat into the freezer, and the customer is, even if it was coming from the customer, which is not, Judge, because I have found another witness and I can supplement that it was not coming from the customer. It's not part of the record. We later looked it up because we were working in the negotiation and for some reason didn't make it. But irrespective of that, there is enough here. He's the one who put it in there. If the customer is picking up, that means that it was already leaking. It shouldn't leak. The testimony by the manager saying they should not put that kind of chicken that it's leaking, meaning they should not put it in the freezer. Whether you and I agree on it, Your Honor, or the defense counsel agrees with it, that's not the point. Their own manager, it's a fact question saying he should not have put it in there. If it was in that state, he should not put it in there, because then if the customer comes in and picks it up, then it will leak from the customer's cart. So that's their own management. The defense attorney, or you and I, don't have to like the evidence, but we cannot ignore the own policies of Walmart and their own testimony. This is their own management. This is their own people. This is not even the plaintiff. This is their management saying, yeah, it looks like it could be my employee. I'm not sure, but either way, he was there. He should have inspected it, and if it was, if he inspected it, he should have seen it, and if he should have seen it, he should have cleaned it. So the 96 rule, that what she's talking about, it makes no sense to me, and that's kind of like trying to pick up law, trying to make an argument. That's when, let's say you have a video that someone slips and fall and there's no employee around. And the question becomes, well, how long was on the floor? Were they aware? It does not applicable in a situation where they create the dangerous condition, which is, even the Fifth Circuit said that, which is federal court, in a situation where the employees are right there. In a situation where the employees are right there in a temporal proximity, the laws have always been, and I've been doing premises more than anyone in El Paso for 20 years, the law has always been, it's a fact question, even if they're close. They don't even have to be in the area, but let's say cashier across, fact issue. They have a constant, in their own handbooks, a continuous duty to inspect those floors. And so should she have seen it from the point where she was sitting or where she was standing? So we've had summary judgment denied on matters where they were like feet away, because it's a fact question pursuant to their policy that they have a continuous duty to monitor the area of work. So did they do that? In this case, Your Honor, this is a black and white situation. The guy is right there. He's in the area. He's on the floor. Walking that area. And not only that, but he's the one placing the product that the leakage came from onto the freezer. So there is actually a contemporaneous activity going on with that employee at all times. And then you have the manager saying, I'm not sure, I'm looking at the video, maybe it was him. And then you have my own client, who, that alone, Your Honor, just an admission by a party opponent as a matter of law, they should have not even, they filed a summary judgment before. This hearing should not have taken place, because that's an admission by party opponent, and that's, as a matter of law, requires the denial of motion for summary judgment. I believe I went above and beyond on my response and addressed additional matters on the deposition that clearly create fact issue. The question before the court is there a fact issue? That's it. Is it a fact issue of he said, she said? And
your question really quickly. Does the testimony by the two individuals, does that pass this? Is it more than speculative testimony? A minute ago, you were kind of rephrasing the testimony that both said it's possible that the substance on the floor came from the packing cart. Not saying that it did or it didn't. It's a possibility. Is that enough to get you past summary judgment?
Your Honor, what's enough to get me past summary judgment, with all due respect, is my client saying she spoke to the manager, they followed the droplets, and it came from the employee's card, and that the manager apologized to her and said, yes, it came from the employee's card. That enough gets me to win summary judgment. And it's in our response also by my appellate lawyers who also wrote the response. That enough, we went above and beyond, but that statement alone, under admission by a party opponent, makes it a he said and she said, to where it goes to the jury. Do they believe my client, or do they believe anything else in light of the evidence? We even have corroboration testimony of video There is a video that specifically shows that the guy is pushing the cart and is working on the area. So it's not like she said something he said and then there's no evidence. Even with that, the court could not grant the summary judgment because it's still a fact issue of he said, defendant said this, plaintiff said that. And so unfortunately, that alone creates a fact issue. But in this case, there is a whole lot more than that. As far as Rachel, trying to read it, I should have printed it out because I'm trying to get to the page. When the own manager that is looking at the video, it says, yes, it could come from the card of the employee. And then you added with my client's testimony who was there and saying, yes, I was there and it came from his card because we followed the card. And that's exactly what the manager said. That's not speculation. It adds on to the testimony. Because she says, you cannot see the leakage on the video, Your Honor. Apparently, with all due respect, Ms. Hernandez apparently can, but their investigation crew and their own manager who looked at the video says they can't. I can't either, because the video is too far for you to see exactly where the leakage is coming from. But what we know, he was right there. He was right there working, and we can't really see from the video. And that's what the manager, this is another manager, not the manager that my client spoke to.
Right.
So
And
when I say
when you keep
Rachel.
referring to he and she, if you'll just use a
I
name.
apologize. Yeah, so
Mr.
it's Rachel.
Garcia. Are you talking
Yeah.
about Mr. Garcia?
No, I'm sorry, Judge. So Rachel Maynes is the other manager. She also was deposed, and I played the video with her. So I'm sorry. So there's two managers, and there is the manager who spoke to my client at the scene and followed the droplet steps, right? And then there is Rachel Maynes, who was afterwards. So Rachel and I played the video together and we went over the policies. So let me kind of go over the
Before you get there,
testimony.
let me ask you this. Are all statements by employees of a company admissions by a party opponent?
Yes, Your Honor, 801 D2. Absolutely. A statement made by any employee while they're at work in a course and scope, it's an admission by party opponent. Absolutely. Federal and state, Texas. So that is a law that the defendant cannot, I mean, that's what, you don't even need more than, you just need one. I've provided the court more than one. So Rachel, we were going over her policy. So she was more kind of like on the policy. She says, we're constantly monitoring the floor for any hazards, correct? Yes. And then she goes to say that each associate has the responsibility to create and maintain a safe shopping environment for our customers. And it's their job to identify and correct potential hazards as they work. So as they work, it's in their policy, and that's exactly, and I provided case law where it says when the employees ignore their policies, that's when the court has even found constructive knowledge on that. But I mean, I've submitted this evidence, Your Honor, but I don't even think it's that grave as it is the admission by party opponent and the video showing the guy being right there. But I mean, this was submitted extra to the court. So page 23 of her deposition. Let me go to the part where she says she's looking at the video. So I asked him, I mean, technically you would agree with me that the employee that is stalking by the cooler and he's right in the location next to the cooler, correct? And the cart is on top of it. Page 31. Her answer is yes. If he saw a damaged package, it would be his responsibility not to place it in the case. So we're looking at the video and we're saying, hey, he's the one doing this activity. And she said, yeah, if he saw that it was leaking, he should not even put it in the freezer. So assuming somebody was playing here with a chicken and there was leakage on the floor as he was pushing the cart into the area, it's his responsibility to make sure there was no blood or water on the floor. Correct. And as he's stalking, it's also his responsibility to make sure that if there is blood or, leakage from any of the packages, that he addresses it immediately by either putting a towel or call somebody. Correct. So we're talking about his duties as we're watching the video. And then she says, I ask her, items that drop off your boxes as you're stocking and cause a spill on the floor is a hazard and dangerous condition. True? Answer, true. Question, and you cannot tell this jury that the employee who was actually contemporaneously placing the chicken from the box into the cooler, that there was no blood and water coming out of the box. You cannot tell the jury that. True? Because you have no way of saying that. Answer, true. So she agreed right there, no objection, that this employee was contemporaneously engaging in the activity of taking the chicken, putting it right back on the cooler, and that she cannot tell the jury that it was not, that there was no leakage as he was doing that coming from the box, as she's watching the video. And she says, true. So, based on that, he was working on that area, and part of his work was stocking the chicken from the boxes into the cooler, correct? Correct. I mean, no objection, Your Honor. I mean, she's saying, yes, he's the one doing it contemporaneously. And then I asked him, we were talking about foreseeability. And I asked her, if you are working, you check the floor, right? Even when you're leaving? Answer, right. And that is his responsibility to do that, especially when he was doing a job right there. True? Answer, true. And then that's when she says, well, I cannot tell whether it was his fault or not because, you know, obviously we can't see the leak in the video. And this is page 40 of her deposition, Rachel. So she even says, I'm not sure if it was his fault or not because I can't really see from the video. And she says, I'm not sure exactly when the leak occurred. It could have been from the cases, but also it could have been from a number. And I asked her, at 106, the spill exists, correct? Answer, yes. This is page, so this is establishing the timing now, page 41. Your employee was on the spill, actually on the exact spill, based on the video, within 10 minutes of the spill, right? Answer, true. He was within that time frame. And then judge, he moves right to the right. He's right there working, but he was literally on the top of the spill. So that's what the argument is, that he came from his cart. And that's what my client said when they actually followed the spill, it was coming from his cart with the manager. And you can see him literally within 10 minutes of that spill on the video. And Rachel Minus agrees with me. So we don't even have to be forensic in here. You have a manager that is looking at the video on their deposition testimony saying, yes, I'm looking at it, and he is on top of the spill within 10 minutes of it. Which means what? He either created it or he ignored it.
And when you're talking about the meat cart being right over the place where the plaintiff fell,
yes,
10 minutes before she fell?
Yes, it's on the video. And that's what Rachel Minus is telling me. So that's what was my argument, that it came from him. And she's like, well, I'm not sure it came from him, but we know he was there within 10 minutes of the spill. And he doesn't really leave, judge. He just goes to he just moves to this other side. Like, so if you look at the area, he just is on top and then he kind of like moves it. So it's either came from him or he ignored it. And that's what she's saying. She's like, I don't know if it came from the cart because we know he's on top of the spill, but we don't know if I can see if it's leaking. And she's right about that. I mean, I cannot see it either. I don't know how anyone can, because the defendant says she can't. I say I can't. Apparently, Ms. Hernandez can, but that goes to the jury, because we'll let the jury, the decision maker, and the fact, finders of the evidence, to look at the video and to determine if they see what I see, what the Rachel Maness see, or apparently what Ms. Hernandez sees, which is not possible, because you cannot see any of that, Your Honor, with all due respect. And I don't think Rachel Maness, who is a store employee and a manager, would necessarily agree with me and not with her attorney, but I don't think they were present when this deposition was actually taken. So that's what's happening,
Let me
Judge.
stop you really quickly. You all provided kind of still frames in I think in both the response and the reply.
Yes, Judge, I took pictures.
So let me make sure, because I don't see any still frames of where plaintiff alleges that the meat cart was over, and I want to make sure that I'm looking at the right thing. So, for example, hang on, let me find it so that we're clear.
So, Judge, if you look at page 6 of my response, there is a screenshot of that. And before, do you see those? And before that,
I think you cut out. You said that's a screenshot of what? Of a plaintiff falling, right?
Yeah. And that's the same area where he was sitting there and working and moving the cart. You can look at the video, or you don't have to look at the video, because Rachel Minus, I just didn't include everything, Your Honor. I mean, I used her deposition because I think having a manager agreeing with you and saying, yeah, you're right, he was there and he was contemporaneously working on there, and yes, you're right, it was his duty to inspect, and yes, you're right, maybe it's actually coming from his car. I think that's a very powerful evidence as a deposition instead of necessarily a video, because a video requires interpretation, right?
Well, and that's what I want to make sure. I read the testimony. I appreciate highlighting the key parts, and I've reviewed all of that, but I didn't see a still frame of that, and I want to make sure that what I'm interpreting is what you all are saying. And so, like in that one screenshot that you provided, it looks like the meat cart is in the blue. No.
Yes, Your Honor.
The side in the aisle.
Right. Well, he moved it. So that's after, right? So he was there before, within 10 minutes. So no, I didn't do all the screenshots because I used Rachel to kind of support that. But I mean, if the court wants me to submit the additional screenshots and provide more, I have no problem. I just feel like it's a matter of weighing the evidence and the testimony.
I'm not weighing it. I'm just making sure that I'm following your argument. And because, as I said, I wasn't provided the still shots. I think you just told me a minute ago that it was at 12:50. So I went back to the video to show, and can you see my screen now? I'm just sharing the video. And the time here is 12:54. Can you see it?
I can see it, but it's not it, because sometimes, Judge, it's the 12:50 and the label, and it's sometimes when you play it has a different timing. So let me and when I use the deposition, I don't know which one I used.
So I stopped the video at where the video itself shows 6/20/2021, 12:54, 10 p.m. And I don't know if you can see my arrow, but I'm pointing to the area that I understood plaintiff fell, and it looks like there's a cart.
That's not that area, Judge. It's right here to the side. So that's not the screenshot I have. So I'm not sure.
No, I'm not showing you the screenshot. I'm showing you where I stopped the video. I don't think you're following me.
But we actually have the video where she fell, and we've screenshotted that. I mean, we have her falling, so I'm not sure.
No, Ms. Avenatti, you're not following me. Okay, you're saying we don't even have to talk about constructive knowledge and the time rule. That doesn't apply because the defendant's employees, at least two of them, say that they don't know how the spill was created, and it is very possible that the meat cart itself that the employee was using created the spill on the floor, right?
Yes and no. They did not say that where it specifically came from. They say it could have come from the guy that was stalking, but they also say he was on top of it. So even if he's not the one creating it, he still had a duty to look at it as he moved the cart and clean it up.
Yes,
so there's
he
two
created
arguments,
it,
Your Honor.
or he had a duty to inspect and clean, and that's
Because
where
he was
the time
there.
rule would have applied.
because he was there. So it's not a matter that there was a time that he wasn't paying, that he left or there was nobody in there. He was actually working on that area. He was in that area, Your Honor.
But my only
So
question to you is the screen that I'm showing right now, the video where I stopped it at 12:54 p.m., does that show the employee with the meat cart in the vicinity where plaintiff fell?
So it's, well, I have a different screenshot in here. It's in this area, Your Honor, to the right, but I don't see the employee. I'm sorry, to the left, but I don't see the employee. And
Well, no,
I
because
can't-
this is not the point where she fell. You had told me that he was in the area, and I thought you said it was around 12:50, 10 minutes before she fell. I think she fell around 1:08. So no, you don't see the
you
plaintiff.
tried
option. I'm asking-
1251, 1251, Your Honor. I don't, it's because I don't have I have a different screenshot here and I'm trying to, let me see.
All I'm asking is if the individual, what I'm looking at around 12:50, now I have it on the screen as 12:51.
Right. Okay. So do you see this employee, Your Honor, that is pushing the carts? He's right there at the stalker. I'm gonna probably have to get the screenshots from my,
Can you see my arrow, my hand?
yes,
So am I pointing at what you're talking about? It looks to be like a male pushing a cart it looks like boxes on it.
right. Yes, I'm looking for the red apron, but I don't see it, or maybe it's just my screen. So I have what I have, and one second. Okay, here it is. Now I see the red apron. Sorry, Judge, it was like hard for me to see but do you see the guy that he's the one who put the card? You see this here? Well,
Yeah.
you can't
Right
see
here?
my arrow. No. Do you see this guy walking right here? Yeah, you're right. I couldn't see the red apron. I was looking for red apron, but he had turned his back. But this is the guy. Do you see how he walked in first? Do you see, Your Honor? He walked in first, and then he's now stalking.
Yes.
This is the guy. And then he pushed it to the side, remember, Judge? And then he goes to across. So this is the guy. Sorry, because the video is a little bit far from my screen and I couldn't tell. I was looking for the red apron.
Okay.
But yes, that's him. I'm sorry. I'm sorry, Judge. So it was at 12:51. He had a red apron, so I was looking for the red apron, but I couldn't see the red. And I was like, I wanted to make sure I said that's him because I remember he had a red apron. But that is the guy. So he goes in, right, Judge? He puts you see all the cards, they all have the chicken, right? So that's the blood came from the product he is carrying and he is pushing. It's in the card. So that's not disputable. So that's what's happening. He pushed it and then he leaves a little bit because it looks like somebody was, and you don't see a customer at that point, right? So nobody's there. So he was working on there. He goes back and then he puts the chicken into the freezer. And then what he does, he moves to the side and then walks away, and the accident happened within 10 minutes of that. So that's when Rachel Maines was saying, yeah, I don't know if it fell from it. But my client says that when she was on the floor and the other manager, Nestor Gracia, not Rachel Maines, okay, so the other manager, when they went in there, because she was in the floor in excruciating pain. Judge, this is a case with a lot of injuries and damages. I mean, you see her on the floor crying, and her daughter was there. So there was another witness, and they didn't take her deposition, and I've spoken to them about conducting more depositions, which is why the mediation wasn't successful, because apparently last minute at mediation we got this alleged affidavit, and so everything was kind of put onto pause. I don't know if the court recalls, there was a sudden change of counsel from Kemp Smith to the new firm, and so when we went to mediation, this thing came in last minute, and then we decided we're going to take more deposition, and that's why I didn't send the affidavits. But in any way, going back, the admission by party opponent, Your Honor, is on the fact that the manager is investigating with my client and the other lady, saying we're following the steps, and they looked where the droplet came from, and it came from the card. And that's what the manager told my client, and my client saw with my own eyes. So it's not even, how is that even a speculation? I mean, that's not a speculation. That's somebody who is there, has personal knowledge, and says, I was there, we saw it. And if the manager said it came exactly from the card, and we can see the guy, he's right there, and he's working. And that's why Rachel Mena says, well, I'm not sure if it fell from his card, meaning as he is engaging in that activity, or he was there and was already there and he didn't see it. But either way, Your Honor, he's the main guy responsible, because let's play devil's advocate and go with their argument, which there's no evidence of that. But let's say, oh, it was from a customer. So there's two issues with that argument, Your Honor. Just because it was leaking from the customer, that doesn't mean it was not also leaking from his card. So it could be two different separate leaks, because the chicken apparently that was in the box that day that was being contemporaneously placed in the refrigerator clearly had leakage. That's clear based on the evidence. So the question becomes, the droplet that caused there to fall, I guess, if you want to be devil's advocate here, is the droplet that came from his card, or is the droplet that came from the customer's card? Because we can have two leaks going on at the same time, because he's the one placing it. But irrespective of that, if he's the one creating the leak, he's responsible because he created it, he caused it. If the leak came from the customer, which is disputed by my client's testimony and by the admission by party opponent, but let's assume that argument for purposes of advocacy, still the summary judgment fails, because who placed the dangerous condition to begin with, which it should have not been in the first place? Well, the employee. The employee put that in the first place for the customer to put on the card. And Rachel Manas and Garcia said, yeah, you shouldn't be doing that. If you see that the package is leaking, you cannot put it in that freezer. That's their testimony. And it's undisputed testimony. So even though that's the evidence does not support this 4 years later argument that it came from a member card, even with that argument, they still fail, because he's the one who caused that chicken to be in customer's cart by placing it in the freezer for the customer to pick up. 1, 2, think about it, Your Honor. The most important argument, he's right there. So if it's leaking, why is he not checking his surroundings? So he's also violating the policy. So even with that argument, their summary judgment fails, because he's the one who put it there in the first place and he shouldn't have. And 2, he should have been inspecting the area as he's working. That's what the policy says, to make sure that if there are anything on the floor, he removes it. And he's right there, and the card is right there, and he's right there. And all this happening within 10 minutes of activity. And if I am a juror, and I believe a reasonable jury can look at this evidence and say, it's his fault because he's the one who created. And even the manager that is a manager for Walmart, is biased for Walmart, is paid by Walmart, is saying, you know what, I'm not sure if it was his fault or not. It could be, but maybe not. It could have been a member. But even if it was a member, yes, I agree with you. He had an ongoing duty and responsibility to look at the floor and make sure it was safe. So this is all this argument that we've caused, when this could have been very simple, based on my client's testimony saying the manager investigated right there. He followed the droplets, and it came from the employee's card, and he apologized profusely. And they all say they never spoke to the customer. This alleged member, they never spoke to the customer. But that the customer could have had another leak. That doesn't mean that is the leak that caused my client to fall, because apparently there was chicken that was leaking that day and should have not been leaking. And if it was leaking and if it was there, it should have not been there because he was right there. And he should have not been there in the first place. He's working on that area. This is not a situation, Your Honor, that 2 hours later, oh, well, maybe it was leaking. We don't know why it was leaking. We weren't there. We didn't know. They're right there, Judge. He's causing it. He's putting it in there. So you either don't pay attention that it's leaking or just ignore that it's leaking and let it and put it in there against Walmart policy. Now, Nestor Garcia did say, you know what? He's been with our company for many times. I would hope he would not do these things. So these are all fact question. I mean, I would hope he would not do these things because you cannot put chicken package that is liquid or potentially leaking in the freezer. And I said, well, Walmart employees get fired every day, Mr. Garcia, for violating company policy. He's like, yeah, that's true. We don't know why the leakage package was there, but you would hope that they wouldn't do that because it's against company policy. I think, Your Honor, with all due respect, I think this is a very strong liability case against Walmart based on all the circumstantial evidence and, more importantly, based on the video. I mean, it's a very rarely that we have a video where we have an employee literally within 10 minutes of a fall working on the very same area and working on the activity that caused the harm. He's not just working, let's say, on produce and was walking around. Just on that alone, Your Honor, if I had an employee walking on the area, that has been enough to deny summary judgment to say, what's the policy? You have to post to check the floor. Fact issue that you didn't follow your job and didn't look at the floor. This is a situation that is so grave. He's the one creating it, and creating it in one came from his card, which the manager says, but also creating by putting those chicken that are not supposed to be there in the freezer.
I understand your
and then
position, Ms. Maldonado.
checking it.
Okay, I need to give Ms. Hernandez an opportunity to respond.
Thank you, Your Honor. I just want to go ahead and hammer in a couple of points before we end today. Again, speculation does not equal evidence. I know opposing counsel has really emphasized that the employee was standing there with the meat cart. She has not provided evidence, again, that the package he picked up in place was leaking, that was even where the leak came from.
Why is it not a fact issue based on not just the video, but the testimony of Mr. Garcia and Ms. Mayness?
There are some issues with the testimony specifically. Again, in the testimony, plaintiff specifically states that she heard from Nestor Garcia and saw him that he followed the drops to the source of the spill, which was the meat cart. If you actually look at the video, he follows it to Norma Mendoza's cart. So there's that, of course. Again, the testimony comes from an alleged statement that was made by Nestor Garcia, who says that he never said that. He actually, in his sworn deposition, says that our understanding of what we were told was that the drop came from the customer's chicken package. And again, we don't even know when, if the employee placed the chicken package, if it was leaking at that time, if that leak existed there. What we do have instead is we have this evidence from Norma Mendoza herself, who was there, that you can see her on the video, who actually even made this affidavit, which is sworn, state again that the leak came from her cart specifically, and it came from her. And this evidence can't be disregarded again because a reasonable jury wouldn't be able to look at this affidavit and turn it away. Again, this witness was there. This witness was disclosed in our fact witness list on July 18th. This witness has been mentioned in depositions before, and she was even disclosed, her information was disclosed again on the customer incident report originally. Speculation does not equal evidence. And again, the interviews with Rachel Mayans, they were all based on hypothetical questions. Could this have happened? That's not evidence that this actually did happen. And with that, I ask you would grant this motion for summary judgment. Thank you.
Thank you
Your Honor,
both.
may I, one minute, Your Honor, may I?
Ms. Lavenati, you've used a lot of minutes. I
Your Honor,
understand your position. I have reviewed everything. I'm going to review some of the cases that we were discussing today. I think the Slape case, I think you mentioned another case, Ms. Lavenati. So I'm going to take a look at those one more
Gloria
time.
Armendariz, Your Honor, it's a Fifth Circuit case, but with all due respect, counsel does not understand the definition of evidence. An affidavit, that is not
Okay, Ms. Lavenati, no,
judgment
let's
evidence.
not do that. Let's not, I've let you, I think twice already, you've commented about Ms.
Your Honor,
Lavenati. We're not here to talk about what your thoughts are or what you think opposing counsel knows or doesn't know. That's not the point of today's hearing. And so please, from now on, refrain from doing that stuff. Let's just stick to the merits of the motion, your response, and that's it. Okay,
Your Honor,
not whether or not you're surprised to be at this hearing or not. It doesn't matter to me whether you're surprised or not. We're here, so let's make the best use of our time on advocacy. I appreciate your presentations. Please, if you haven't already submitted a proposed order, please do so by emailing Ms. Dunlap. I'm going to take the matter under advisement, and then I'll enter a ruling likely next week.
thanks, Your Honor. I just want to clarify something. An affidavit of a witness who is not a party and it's not a deposition, it's not proper summary judgment evidence. What's proper summary judgment evidence? It's actually depositions testimony by parties and admission by party opponent. So, and as the court should also, I understand that
Hey, Ms. Lavenati, I'm not going to allow any more. We've already gone for an hour. And that's what the purpose of your argument is for, to raise any objections. I know you talked about raising objections to certain evidence. I never really heard them other than that you
they're in
didn't
the
really
brief,
like
Your Honor.
them. But I read the briefs and I understand it. I think there's hearsay issues on both sides. And so I'm aware of that. But at this point, I totally understand everyone's positions and I will take the matter under advisement. Thank you both very much. Have a wonderful weekend.
Thanks, Your Honor.